Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers evictions, stop and identify laws, and police searches, and it's brought to us by Alan Bailey's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into today's interaction, I just wanted to give everyone a quick reminder that if you pick up your copy of the Civilian Rights Hand Guide today, it should still arrive before Christmas. Now, for those of you who haven't heard, the Civilian Rights Hand Guide is a comprehensive guide designed to empower everyday citizens with the knowledge they need to navigate police interactions confidently and responsibly. We spent a lot of time making sure that we wrote a high-quality and thoroughly researched book that covers everything you need to know when interacting with the police. Whether you're looking to protect your rights, educate yourself on legal principles, or ensure your loved ones are informed, this book is the perfect resource for leveling up your legal knowledge. And it would make a great gift this holiday season. If you like the content that we produce on this channel, then picking up a copy of the Civilian Rights Hand Guide is the best way to support what we do and get something useful and valuable in return. It's available now exclusively on Amazon, and you can find a link in the description and pinned comment below. Thanks again for your support. On February 6th, 2024, several deputies with the Hillsborough County Sheriff's Office, including Deputy Francisco Diaz Rodriguez, responded to a call regarding an allegedly unauthorized entry onto a commercial property in Hillsborough County, Florida. When the officers arrived at the location, they found Curtis Bailey, the lessee of the property, and his brother, Alan Bailey. The interaction that followed was captured on Deputy Diaz Rodriguez's body camera.
Let's figure that out real quick with
Sounds like a big city.
Let me check. I'm just going to check. Yeah, you want hang on one part real quick. Go with him real quick to get the phone so you can call the owner.
Yeah. Well, the owner, he barely thinks that he can do it without knowing to find off. We are the ones that police it. He's not. Let me see about calling it. Let's see if we can find it. It might be in this truck too.
What, your ID?
The phone, the other phone. We're looking for his other phone.
This is your shop?
Yes, currently it is until either the eviction goes through or until we leave. And we're almost done leaving. Bring my phone. Bring the phone.
Do you have your ID with you?
I haven't broken the law yet.
Do you have your ID with you?
Of course I do.
Hey,
I'm walking over here.
No. You're gonna come over here. I'm talking to you here.
Okay.
Do you have your ID with you?
I do. I already answered that.
Can I please have it?
You asking or is it?
I am asking, yes.
All right.
We're here in a call, so we gotta.
I get that.
Okay.
I get that.
So can I please have your ID?
I'm respectively saying no at this point. Only at this point. Okay.
And why do you want? Do you not?
Why do I have
ID?
to? He's the one that owns
Sir,
the. Let me finish, please.
Sir, listen
He's
to me.
the owner of the.
Besides,
he's the owner of the property.
Besides the story, what's your name?
Alan.
My name is Frank. Deputy Diaz Rodriguez, as you can read right here.
I would never be able to say that. But
okay. It's Diaz Rodriguez. You can just
D-
repeat after me.
Diaz Rodriguez.
Yes.
Yeah, the Rodriguez.
Okay. Do you have an ID?
Yes, I do.
Okay, can I please have it?
Once we determine what's going on,
they are doing that part of this call. I'm doing this part of the call.
I do not have to help you with your investigation. I can stand here, be quiet.
Okay.
And I'm not doing that. I gave you my name.
Okay.
Okay. I haven't committed a crime, at least not that I know of either.
Mm-hmm.
And that.
How old are you?
Huh?
How old are you?
60.
60.
Okay. So
is that your car?
That's it. This is all his.
So all of these cars are his?
These two cars are his.
None of these cars here are registered to you?
Pardon?
None of these cars here are registered to you?
I'm not making out. None of these cars are what?
Registered.
Registered.
To you?
No, none of them are registered to me. Can I go get my drink? Just my drink? Right there?
Sure.
I understand that you guys do your investigation and stuff like that. I, myself, is just here helping my brother out.
Okay, I understand
I have
that.
no other interest in this except that I heard him When he found out, he came because the owner, I talked to him like 2 days ago. The owner, I was here picking up some stuff on a cart. It's somewhere around this corner here. And, he told me a little bit what was going on, and stuff like that dealt with this situation. I said, all I'm here is to help him get his stuff out of here and stuff. And the owner said, fine, no problem. He said, well, he's going to have people work on cleaning up the property or cleaning up the stuff inside. I go, great, no problem. And he says, I'm not going to call and have all this towed off or anything. I go, right. He says, is your brother going to give us the key? I go, I don't know. I don't know what's all going on. So we know that he started some stuff, but it has not been completed. We have not been evicted by his lawyer. His lawyer, he knows who his lawyer is. I don't know his name. Said that he checked on the dockets and see if there was anything, if a writ of possession was done yet. And he said, nope, it's not been done. You haven't got one delivered to you. And he said, nope, I didn't even know there was one coming. And the lawyer says, well, you still have controlling interest of the property. Go ahead and cut the locks. And we cut one lock.
Your lawyer told you to do that.
Mr. Bailey explains that his brother still has a right to the property because he has not been served a writ of possession. Under Florida eviction law, a so-called writ of possession is a court order issued to enforce an eviction judgment that allows a landlord to regain possession of their rental property. Now, before a writ of possession can be issued, the landlord must file an eviction lawsuit against the tenant. If the court rules in the landlord's favor, a final judgment for eviction is entered, and the court will issue a writ of possession. As Section 83.62 of the Florida statutes explains, quote, after entry of judgment in favor of the landlord, the clerk shall issue a writ to the sheriff describing the premises and commanding the sheriff to put the landlord in possession after 24 hours' notice conspicuously posted on the premises. Accordingly, because Mr. Bailey's brother had not yet been provided with the 24-hour notice required, a court would likely find that he was still entitled to possession of the property.
His lawyer.
His lawyer.
Yeah. Well, it's just like, this is a totally different situation, but it was still following the same scenario.
Do you have any property here?
Say that again?
Do you have any property here in this premises?
Yeah, well, yeah, we do. Not me. My brother does. That's his truck. That's his frame that body that is supposed to go on. Okay. So, the owner, and this part here, a lot of this is just hearsay. I can only tell you what I was told. Okay, because I'm not into this at all.
Right.
Okay, so the owner told my brother that he was thinking of selling the property. Get that. And so a couple of people just came by to look at the property and stuff. But then out of the blue, the next thing we're being told that we got to move. Not me, he is. And so I came down there.
So is he the owner or not?
He's the leasing party. He leases.
He's the leasing party, okay.
So he's the leaser.
Where's your brother?
That's him there. The guy standing over there in the black.
That's your brother?
Yeah. Okay. He's the leasing party. The guy wanted us out. He was the only one was doing it. I came down to help him. We got more and more stuff out. If there is an eviction, it hasn't gone to court, it hasn't been adjudicated or anything yet. That's my understanding by what the lawyer said earlier today.
Okay.
Chris, I believe the property owner's name, told me that we can come and get anything that we need to get off it. This was 2 days ago. And so then we come and we see the locks on there, we call the lawyer. Kurt's waiting for this phone so that he can call whoever it is he needs to call. Okay. So if you don't mind me giving him the phone so he can at least call whoever he's got to call.
You mind me getting your information, see if there's any injunction in the system that has anything to
Say
do with
that-
you? Can I have your information so
There
I
won't
can
be
check?
I won't be in the system at all about this. Again, I came from Michigan
Okay.
2 weeks
Do you
ago.
have an idea with you? Can I please
Remember,
have
I
that?
did say that I did.
Can I please have one?
I don't want my name.
You don't have
Mentioned
your name
in the
is not,
system or
you're
not?
not gonna be your name is not gonna be mentioned.
You're going to
anywhere.
You're going to call in and see if there's any wants or warrants for it.
No, that's not what we do. We document everything we do. Everybody with
Well,
that we come in
then
contact
you can
with.
just document that. Right at the moment, I'm a law-abiding citizen. As far as I know, I have not broken any laws.
You are
Go
being uncooperative right now.
Well, I appreciate that you realize that, and just because I don't feel
do.
that I need to ID
Okay.
myself is not.
Do you have your ID on you, boss?
See, this is what he's saying.
And he's refusing, so he's going to be in handcuffs in a couple of seconds because
I'm going to be handcuffed. You just got through saying that
until I
I'm.
know who you are, you're not going to leave
That
here.
is not a reason to
I just told you
handcuff
right
me.
now. Until I know who you are, you're not going to leave here.
I'm not leaving here.
Okay.
You have to
How many
identify yourself.
cops are
You're
here?
going to be
Yeah,
in the back of my
it's
patrol car in a couple of seconds if you don't give me your ID. How about that?
All right. Well, I'm going to start recording now.
Okay.
You are denying me the right to record.
Stop.
I got a prosthetic leg.
Put your hands behind your back.
Get up, sir. Come on.
Give it. Let me have it.
It's not that hard.
How you
It's not that hard. Put your hands behind your back.
Hey.
Oh, you want to act stupid.
No, my leg is falling off.
Okay.
God damn it! Look at that. You.
Listen. I'm
Let me-
going to say it one more time.
I-
Look it up.
I
Look
will.
it up. Okay.
I was showing you my leg fell off, and you didn't
You
care.
didn't have to do that.
I told you before I kicked
Okay.
it off that it
Okay.
was coming off.
Okay.
Go back.
Now I'll grab my leg, I'll put it on, and I'll stand
Okay.
up, please.
All right, so stand up.
Go back. Over there.
Thank
Here's
you.
your leg.
Go.
Thank
Hold
you.
on.
Yeah, we're
Thank
helping
you.
him. We don't need you over here. Goodbye. That's great. You are too. We're trying to get his ID. I guess he's refusing identity.
Because I haven't broken the law.
It didn't need to get to this level.
I didn't do nothing.
Focus on putting your stuff back on so we can continue what we're doing here, okay?
What,
All you-
violating my rights?
No, nobody's violating your
Well,
rights. All you
yes,
have to
because
do-
I haven't
Can I finish talking?
No, because I haven't broken the law.
Okay, you're asking.
I have to. I can
Listen,
only have to be
okay.
verified myself
No.
if I break the law.
All right.
No.
Hurry up and put that
Yes,
stuff
it
on.
is.
Put it on. Hurry
It's a
up.
federal Supreme Court
Put it on.
ruling.
Hurry up. Put it on.
Yeah, what happened to you just got through saying that
Just
I
finish
was
putting-
being-
just finish
Hey,
putting it-
I'm asking a question. I'm allowed to
you're
do
not
that.
asking the questions here.
I am
I'm
too.
asking the questions
I-
here. So
I
now,
don't have
so
to answer
before,
anything.
So before I get you up,
I don't have to
before
answer
I get
anything.
you up, listen to me.
Plead the fifth.
Listen to me. Before I get you
I
up.
have a right to remain silent.
Okay, no problem.
Put your shoe on.
See, I have no toes.
Okay.
Nobody cares. Go. Put it on.
That's right. Nobody cares.
Put it on. Put it on. Hurry up. I'm
Well,
trying to
that
help
is
you.
your
I'm
mandatory.
trying to help you, or you're gonna go to jail without no shoes and without no legs.
All right. Put your foot in front of that, please. Go.
Do you have your ID with you for the last time? 'Cause
How
I'm-
many
I'm-
times? How many
The last
times?
time.
I told you I did.
You
have.
do. So are you gonna provide us with your ID?
Under threat of arrest, yes.
No. No.
I'm going to under
nobody's
threat of
threatening.
arrest.
Nobody's threatening you.
Well, you just got.
My man,
Don't.
my man,
You're making
my
me
man, my
lose
man,
balance.
My man.
You're gonna make me lose balance.
My man.
Listen.
My pants are falling
My
down.
man.
Under threat of arrest, I will ID. If you're not going to arrest me, I refuse.
This is not how that works.
Yes, it is.
No, it's
After being placed in handcuffs for attempting to film the encounter, Mr. Bailey agrees to provide his identification under threat of arrest, but the officers refuse to allow him to do so. As the Supreme Court explained in the 2004 case of Heibel versus 6th Judicial District Court of Nevada, quote, "In the ordinary course, a police officer is free to ask a person for identification without implicating the Fourth Amendment. In these circumstances, citizens are free to decline to provide identification, and they do not not have a legal obligation to comply with a mere request. Now, on the other hand, in a situation where an officer has reasonable suspicion to believe that an individual is involved in criminal activity, they may detain the individual and, in some jurisdictions, require them to identify themselves. Section 901.151 of the Florida statute states that, quote, whenever any law enforcement officer of this state encounters any person under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a violation of the criminal laws of this state or the criminal ordinances of any municipality or county, the officer may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances surrounding the person's presence abroad which led the officer to believe that the person had committed, was committing, or was about to commit a criminal offense. Now, despite the fact that this statute does not include a requirement that citizens provide identification to officers during a Terry stop, courts have concluded that the failure to provide identification can constitute obstructing or resisting an officer in violation of Section 843.02 of the Florida statutes, which prohibits resisting, obstructing, or opposing an officer in the lawful execution of a legal duty. For example, in the 2015 case of Moore v. Peterson, the 11th Circuit Court of Appeals, which has jurisdiction over Florida, held that, quote, when an officer lawfully conducts a Terry stop, Florida Statute 843.02 authorizes the officer to arrest a person who refuses to provide identification in response to requests. Likewise, in the 2024 case of Colin v. Smith, the 11th Circuit concluded that Florida officers had arguable probable cause to arrest an individual who did not present his identification during a lawful Terry stop when the officer requested his identification 8 times. However, there are some distinctions between this situation and these cases. While a court could potentially find that there was reasonable suspicion to detain Mr. Bailey, when Mr. Bailey declined to provide his identification, Deputy Diaz-Rodriguez had not communicated to him that he was being detained or that he was not free to leave. Mr. Bailey also specifically asked Deputy Diaz-Rodriguez if he was required to provide identification, with Deputy Diaz-Rodriguez responding that he was only, quote-unquote, asking for the ID, and Mr. Bailey then respectfully advised that he did not want to share his identification at this time, leaving open the possibility that he would provide it at a later time.
Do you have your ID with you?
I do. I already answered that.
Can I please have it?
Are you asking, or is it?
I am asking, yes.
All right,
I mean,
until
we're here in a call, so we got to
I get that.
Okay.
I get that.
So can I please have your ID?
I'm respectively saying no at this point. Only at this point. Okay?
Once Deputy Diaz-Rodriguez made it clear that he was demanding identification rather than requesting it, Mr. Bailey agreed to provide it, but the officers refused to accept it. As such, Mr. Bailey would have a strong argument that his conduct did not rise to the level of resisting or obstructing the officers.
Yes, it is.
No, we're here for a lawful reason.
That's right. Until I have broken the law.
Okay.
And been
Okay. You're gonna go in the
What
car
is my-
because you
That's
can't
fine.
listen. You cannot listen to what we're
All right, let's
explaining
go.
to you.
Let's go. Sit in the car.
Turn around.
Hold on.
Put your hands behind your back.
Give me a
Let go of
second.
the
Give me a
car.
second. Get my feet right.
You're doing a little too much.
All I'm doing is talking.
No, you're not. You're not doing anything that was asked you to do.
What?
You asked me the ID. I
What?
asked not the ID.
What?
That's not how this works.
Yes, it is.
It's not.
I said I will give you my ID under a threat of arrest. So if you want it,
You think
I
you're
will
like a
give it to
sovereign
you.
citizen or something?
No,
Is that what you think?
I am not a sovereign citizen. It's my
Do you have any weapons
constitutional
on
right.
you?
So an awful search. You can pat me down, but you're not allowed to search me unless I'm under arrest.
Mr. Bailey argues that the officers can pat him down, but they cannot lawfully search him unless he is under arrest. In the 1973 case of U.S. v. Robinson, the Supreme Court held that, quote, in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a, quote-unquote, reasonable search under that amendment. This means that whenever officers place a citizen under arrest, they can search the person, their clothing, and their pockets without violating the the Fourth Amendment. On the other hand, during a Terry stop based only on reasonable suspicion, officers may conduct a so-called pat-down search to determine if the detainee is carrying a weapon, if the officer is justified in believing that they are armed and presently dangerous. However, the Supreme Court clarified in the 1993 case of Minnesota versus Dickerson that, quote, a protective search permitted without a warrant and on the basis of reasonable suspicion, less than probable cause, must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. The court in Dickerson did make an exception for objects that are immediately identifiable as contraband by so-called plain feel, concluding that officers may seize the contraband under such circumstances. However, during a Terry frisk, officers generally cannot reach inside a citizen's pockets or remove objects from them unless they feel something during the pat-down that feels like a weapon or is immediately apparent as contraband. Accordingly, Mr. Bailey is correct in his assertion regarding when a full search may be performed. However, it does seem that Mr. Bailey was being arrested rather than simply detained at this point in the encounter, which means that a court would probably conclude that the full search of Mr. Bailey's person was lawful if the underlying arrest was found to be lawful. But if a court concluded that the officers did not have probable cause to arrest Mr. Bailey, then the full search would likely also be a violation of the Fourth Amendment. Deputy Diaz-Rodriguez mutes his body camera, and the body camera remains muted for approximately 45 minutes. When Mr. Bailey begins speaking to him from the back seat of the police vehicle, Deputy Diaz-Rodriguez unmutes his camera.
Per TPD, got a call about a black male juvenile, and a general 36, no one seen. Anything we say you want?
Give me a second, okay? I'll talk to you in a minute when I'm done doing my paperwork.
10-4, he using 94.
What gets me is I told you I would identify under
1751 hours.
threat of arrest.
That's not how that works, man.
It is how it works. You just can't walk up to someone that's walking down the street and say, I want to see your ID. I mean, what is it to be secure in your papers and property? Isn't that one of the amendments to the Constitution?
So you live in Michigan?
Yeah, I live in Michigan.
On Main Street?
Not anymore, no.
So where do you live now?
It's on my driver's license. That I'm saying.
No problem. Listen, it's okay. You're good.
You didn't tell me you didn't have it with you.
Be quiet, man. I don't need you. I don't need you. You're fine, okay? Just stay back there until I'm done with my paperwork, and then.
And criticize my government.
Okay, do that.
Well, I am because I didn't do anything. I told you I would identify myself under a threat of arrest. When I said, "Are you asking me, or are you telling me that I have to identify myself?" And you said, "Ask," and I said, "Well, I would like to politely refuse to do that, but I gave you my first name. I did."
Can you put me on a
51 at
901 Brent?
Mr. Bailey was charged with resisting an officer without violence in violation of Section 843.02 of the Florida statutes. He also obtained the body camera footage from multiple deputies involved in the encounter and shared the videos on his YouTube channel. Mr. Bailey indicated in the description for some of the videos that he had filed a motion to dismiss the charge against him. No record for this charge was found in online court records, which may indicate that the charge against Mr. Bailey was dismissed, or he was found not guilty and he then had the record expunged. However, I was unable to definitively confirm the outcome of this case. Overall, Deputy Diaz-Rodriguez and the other Hillsborough County deputies get an F for maintaining disrespectful and unprofessional demeanors throughout the encounter, arresting Mr. Bailey when he was willing to provide his identification under threat of arrest, and using unreasonable and unnecessary force on a man with a prosthetic leg. Deputy Diaz-Rodriguez also failed to effectively communicate with Mr. Bailey, telling him that he was only asking for his identification, clearly indicating that he was not required to provide it. Then, later, changing his mind and arresting him for not providing identification in response to this request, despite the fact that Mr. Bailey unambiguously agreed to hand over his identification once the officers made it clear that doing so was not optional. For reasons I cannot begin to understand, the officers refused refused to accept Mr. Bailey's identification at this time and continued to perform a completely pointless and potentially unlawful arrest rather than just simply take his identification. I believe it is also important to call out the officer's total lack of accommodation for Mr. Bailey's disability, with Deputy Diaz-Rodriguez in particular demonstrating disdain towards Mr. Bailey as he struggled to remain standing during his arrest. As public servants, law enforcement officers should demonstrate respect for all citizens, with particular consideration being given to those with disabilities. The Hillsborough County deputies utterly failed in this regard, and the thoughtless way in which they handled Mr. Bailey's disability was entirely unacceptable. Mr. Bailey gets an A-, because although he was not entirely correct in his arguments regarding when he was required to identify himself, he asserted his rights calmly and respectfully, and he was willing to provide identification under threat of arrest, even though the Hillsborough deputies refused to accept it. However, while I do not believe that Mr. Bailey violated the law in this situation, he repeatedly stated that he was not required to show ID unless he committed a crime. As we have discussed before many times here on ATA, this is a common misconception among members of the general public and auditors alike, and the relevant case law has actually established that in jurisdictions with so-called stop and ID laws on the books, citizens can be required to identify themselves whenever an officer has reasonable suspicion of criminal activity. In other words, even in situations where an individual has not actually committed any crime, they can be required to identify themselves if an officer has a fairly low level of evidence indicating that they may be violating the law. This is an important distinction, and it is essential that citizens understand that there may be situations where they can be required to identify themselves when they have done absolutely nothing wrong. That all being said, I still want to commend Mr. Bailey for his willingness to stand up for his legal rights, and I would encourage him to continue to learn about the Constitution and the ways that courts have interpreted it. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.